Amalas, your lordships has heard us very patiently. I've either been present or been made aware, Malas, so your lordship may take it. I know, Malas, the broad trends of the argument, and I'll answer them one by one. From mere cohabitation to a mere, I use the word mere, Malas, declaration of same-sex marriage, to a further declaration of same-sex marriage valid under SMA, which is what I'm asking. There's a difference between my 2 and 3 Malas. Same-sex marriage valid under and through SMA. From that, this whole Malas excessive to the point of being Malas actually wrong emphasis on legislative intent. Put in 5 different ways. Go to the legislature, original intent, rewriting, judicial legislation, judicial surgery. I'll be dealing with all. I'm just saying, I'm cognizant of all that. Then to the what we call the scare argument. Oh my lords, how will it work? The workability argument. It's an attempt to create. I'll be dealing specifically with the workability argument. And then finally to the notice and objections. Now, I will be very pointed. It may not happen in the sequence my Lord would want it, but I'll be covering all this. But my arguments are broadly under 3 heads. And your Lordship members kindly consider following those 3 heads because they will come. Sometimes your Lordship's query may relate to the 3rd head. Lordship, rest assured, it will come there. The first head, with great respect, is that a constitution compliant reading.
We didn't respond to this, my lord. Your lordship said we'll not go into this. Notice and etc., my lord.
No, my lord did not give a judgment, Your lordship made an observation.
We're not going into it in these.
With respect.
Did say, therefore, we didn't.
As I recall, when the arguments were being addressed,
I argued it fully in the opening.
We said that this is common to, this is not specific to the same-sex
heterosexuals also.
And therefore, we said we'll not really deal with it in this batch. We have petitions which are pending.
That's what your lordship
segregated. I have petitions.
That's what we didn't waste your lordship's time.
I argued it fully in the opening.
But Dr. Singhvi, keep it aside because we haven't heard them. Otherwise, we would have pointed out to them that they have missed out on.
That is, according to us.
Purposefully, we did
that. That is, if your lordship has to hear them briefly on that tomorrow. That is the heart, the heart of our objections.
No, 1 second, Dr. Singhvi, we have petitions which are pending specifically on this challenge. And the reason why we thought we'll not deal with it in this batch of matters is that that's a matter which is common to both heterosexual couples as well as to...
I was addressing that argument. Your lordships, just 1 minute, Mr. Manu.
I'm sorry.
But your lordships observed, when I argued it fully in the opening, your lordship said that because it is common, I said, just 1 second. I said that merely because it is common to another segment.
If you don't mind.
I'm sorry.
Inherently unfair to the learned solicitor and all those who followed on this side that they went by our telling them that we are not going to.
Can I just clarify? I hear a lot
of with the subject wise and we consciously decided
that is saying what you are
and in a sense, our suggestion really led them to a sense of
no. I am with it. Far be it from me to take away any natural justice from anywhere. That's not the point. Give me just 2 minutes. I raised it, argued it fully. In the course of arguments, your lordship observed, at which time only Mr. Ramchandran was there, Mr. Grover was there. They protested that this is the heart of our claim. The lordship said we'll take a call later. Now, if procedure is violated, your lordship certainly may hear them briefly tomorrow. But according to us, the heart, but I'll take only a very short while on that. I've argued it fully in the opening. Your lordship's point was that if heterosexual couples to whom this regime equally applies are not present before us, should we not take it separately? That was a short point made, brothers. I have dealt with it fully in my written submissions. Brothers, your lordship's
Dr.
test is a
Singhvi,
positive test.
see, Dr. Singhvi, just answer this.
Yes.
We were not here when the reference was made. There is no reference order per se. But the order was implicit on this premise that the claim for same-sex marriage was being considered. The court, to be fair to the court, nobody pointed out these nitty-gritties of the claims, the details of these claims, or even Section 7 SMA. Therefore, to stand up and say, we have been heard, and please insisting that we must be heard and you must have a ruling is not up to you.
No, no,
Because, see, the
everything
orders
ultimately
don't
up to that
reflect.
side, brothers, your lordship will
There
decide
is a
that.
consensus. The consensus was that let the same-sex marriage claim be heard.
Well, can I just say, your lordship will recollect, I argued almost for half an hour on this issue.
You did.
Then, Malas,
no
after
doubt,
that,
but
I'm Malas, ultimately the only issue is the lordship has not heard them. Your lordship may hear them briefly because, Malas, your lordship's test is, give me a minute. My lord, the Chief Justice's observation, I just want to take 2 minutes on that. Your lordship's test is that is an identifiable class genuinely aggrieved with locus before me. If a genuinely aggrieved identifiable class like me, which is directly agreed by that is before your lordships, then your lordship will not hear me on the basis that another class also is not before your lordships. The only issue are heterosexual couples we are not concerned with, Balas. We are saying that the notice and objections regime, well, ultimately it boils down to
But
only
look
time.
at it this way.
Time, Balas.
One second.
Some time.
There's another problem.
Yes.
Your argument in the challenge to the notice provisions
Yes.
postulates a verdict in your favor that there is a right to marry under the Special Marriage Act.
Of course.
All right. Now, therefore, the question as to whether otherwise the notice provision doesn't apply to same-sex couples at all. Right? Therefore, at the highest, and taking your argument at its highest,
Correct.
your challenge to Section 7 and 10 has to be deferred to a point when we have ruled on the legality of the
I'll tell your
claim to a
lordship-
same-sex
well, may I
marriage.
say why that might not be correct? Just give me a second. Well, it's your lordship will the first step have to see whether I am same-sex marriage recognized under SMA. That was my lord's observation. That gives me access to marriage under a secular agnostic statute called SMA. It does not give me equality
Also,
with my.
Dr. Singhvi, you have to argue on a demurrer.
Yes.
You have to say that even assuming that
Yes,
you are not
correct,
with me
correct.
on the same-sex marriage issue,
Yes.
even then, my challenge to Section 7 and 10 will survive. Can you say that?
No, but that I'm not arguing, Wallace. I'm arguing on the basis of both. I'm arguing cumulatively. I'm entitled to say.
But we would
that,
have
Wallace,
heard you in your petition
No,
on
may I say-
Section 7 and 10 if you were right in saying that even if you hold against me on the first point, my second point will survive.
May I put it like
Your
this?
second point
Yes.
is really dependent on the view which
Wallace,
you take
I
on the
bow
first
down.
point.
I bow down.
And therefore, at the highest, what we can do is this.
The two are
That
inextricably intertwined.
at the highest, what we could do is this. Assuming, because we are now testing the hypothesis.
Yes.
Assuming that we give a declaration as that you want, that you are entitled to a right to marry under the Special Marriage Act, that there is a right to marry, so on and so forth. We can say that this particular issue will be dealt with separately in a petition which you will file or in the pending petitions where you may have intervened or.
Petitions are there on this specifically. Mine, Mr. Rajuram Tanda's, others, all directly, already pending here. And they were mentioned, they were added
Because
to this.
notice applies to those who are entitled to marry undoubtedly, because that's why a heterosexual couple there's a square challenge. But
on
we
this-
can't hear your challenge unless we rule on your basic point.
Well, I leave it to your lordships with 2 points.
Singhvi, we might be putting the cart before the horse.
Well,
That sense of the.
May I just say this?
That's
I'll
why
leave it
we-
at that. Let me state my point and I'll leave it. My point is number one, your lordships would decide certainly the declaratory part under SMA. Number two, my point is when I bow down, my second point of notice and objection arises only if your lordship holds me eligible under SMA, no doubt. However, I say that if your lordship so holds in the first part, the other is inextricably intertwined. It follows, it's consequential. Without that, much of my right is hollow. And thirdly, Malas, the ultimate objection to this is what? I mean, we are in the Supreme Court. Your lordship will hear another combination. But the only objection is that he has not argued. Your lordship will give him a fixed time, half a day, we'll finish it off tomorrow. Malas. I have already argued. We will take less than 50. At the end of the day, your lordship is rightly concerned about natural justice. And I'm not suggesting your lordship violates that, Malas. That's Malas, the only way to put it, Malas. Otherwise, I leave it to my lord, Malas. It's a very, I will show, Malas, at the end 10 minutes, why, Malas, assuming your lordships were to give me a declaration that I am a same-sex valid marriage under SMA, the vulnerability the practical operation, the invitation to violence will make that right 50 to 70% illusory. That's the reason. Your lordship completes the. Obviously, if your lordship doesn't hold with the first part, there's no point. Your lordship doesn't have to bother. What will, at the end of the day, what is the objection? He didn't get a chance to argue. According to our understanding, I was not here. My learned friend tell me, lordship said, we'll see later. Your lordship did not exclude the point.
For a particular reason which will
Did not exclude the point.
to explain.
Therefore, Mullahs, I suggest, at least let me finish my argument on that, whatever little argument I have. Your lordship and Mullahs, accommodate him in, it's a very short point. He can Mullahs show those sections and then your lordship may have a little bit of spillover.
Due respect, Dr.
Dr.
Singhvi,
Singhvi,
with due
Dr. Singhvi.
respect. Yes, sorry.
Yes.
Yes, this call,
Yes,
please.
with the call.
Yes. Dr. Singhvi, see, what is being suggested to you is let the bench rule on the principal aspect. Are you entitled to the declaration of a marriage or not? You are talking about the right post that being illusionary in some manner because of consequences which may flow. It's not that you are being shut out of that right to argue that.
I appreciate it. I
The only
appreciate
thing is that it is being felt that since it's an interlinked issue both for the same-sex marriage as well as a heterosexual marriage, it may be more appropriate to hear that out in a particular manner, looking to both sex of the people. I don't think that should trouble you so
it.
much.
I cannot say more than that. I will leave it at that.
There are only two things which can happen. One is you get a declaration, in which case you are heard on the second aspect. Second is you don't get a declaration, then really you can't argue that.
Well,
So it's really cutting you
I
out.
appreciate what my lord is saying. I bow down to it. I will not say more. I made my 3 points. Whether your lordship then Mullahs still would want to hear it at a subsequent hearing, that's your lordship's Mullahs prerogative. But Mullahs, I would still say the lordship will consider seriously my 3 submissions. That's to why your lordship should hear it in this bench. But I don't want to Mullahs, I want to move
Now,
on.
on the
I-
main matter, you
hear-
said you had 3 points, basically, 3 heads.
Third was this, Mullahs. Third was this.
Alright. What is the
So
fourth?
the first is, Mullahs, there are constitution compliant reading of the Special Marriage Act is within, don't give it down, is within the bounds of legitimate statutory interpretation. That's the first head. These are the heads, fellows. It is neither judicial surgery nor judicial legislation. There are 7, 8 major points under this. I will itemize them and go one by one under them. My second major head, Mullahs, is to Mullahs assure your lordships and assuage all the needless apprehensions created, to show to your lordships, Mullahs, that the relief I seek, in one sentence, Mullahs, I am a valid, recognizable same-sex marriage under SMA. That's the proposition. I am, Mullahs, my second head of submission is that the relief I seek is workable. So the workability head. And neither requires this honorable court to create any new social institution. Many of these are phrases picked up from the respondents. Mullahs.
Social institution.
Nor to have a new definition of marriage. Nor to have a new definition of marriage. These are all again phrases by the respondents. Your lordship will be creating a new definition of marriage. Your lordship will be creating a new social institution. Nor, thirdly, nor entering into any thicket of personal law or other related laws. My third set of head, Lordship will note it. Lordship will decide whether to hear me now or later. Just note the head, brothers. I mean, this is the
Sure.
that, brothers, the prayer for striking down the notice and objection regime of the SMA. The prayer for striking down the notice and objection regime of the SMA. You keep it here and there. Is an essential and indivisible component. Essential and indivisible component of my prayer for marriage equality. My whole case is about marriage equality. This is an essential and indivisible component of that prayer for marriage equality. Your lordships, without this third head, would have granted a recognition of same-sex marriage, but not equality. It would be a recognition of same-sex without equality. We are seeking two things. One is marriage equality. Your lordship would in some sense grant marriage, but not equality without this third. That's why it's important. And as my learned friend rightly says, without recognizing the extreme vulnerability of the class which faces this notice and objection regime, much of the relief might be made illusory. It's a very, very clear, strong, special vulnerability. I will stick to these three heads, I'll start with the first. Now, all these are points under the first. So, just two sentences on what is the heart of my claim and prayer, and then we come to the first head straight away. Well, as I've said, we not only seek or we do not merely seek a declaration of the right to marry, which is one way of putting it. Of course, the solicitor opposes even that. One particular class of respondents said, yes, you may give that, but not go further. We do not seek merely a declaration of the right to marry, but a right to marry under the SMA by an interpretation of the SMA which would allow for solemnization and or registration of non-heterosexual marriages. That's the heart and the complete case. Therefore, Malus, what we seek is a right to access on equal terms. We are seeking a right to access this social institution called marriage and on equal terms. The irony is, my learned friends accept that it's a very sanctified social institution. People must have access, but they say not you and not on equal terms.
Through law.
So, Malus, in a nutshell, this case is about interpretation to apply an existing law in a non-discriminatory fashion. There is no judicial legislation, no judicial surgery. Your lordships, fellows, have done much, much, much more. Interpretation of an existing law, no new lawmaking, but in a non-discriminatory fashion, which has two components. A, I should have a right to access on non-discriminatory terms. B, on equal terms. Now I come to my first head, straight away. First head. Melis, the heart of this matter is what? Your Lordship is, I'll deal with this bogey of excessive reliance on the legislature. I'll be dealing with this constant argument. Well, is the Constitution, just to digress for 30 seconds, the Constitution is supreme. Because your Lordships, fellows, interpret entrenched rights in a counter-majoritarian manner against the majorities. Every day, your Lordship, the whole Constitution about interpreting and applying entrenched rights against the majorities, against elected legislatures, against electoral majorities, which your Lordships from the framers' time thought could become tyrannical and dictatorial. Otherwise, there'd be no constitution. This constant hearkening that you are the judges, unelected judges who enforce entrenched constitutional rights against elected legislatures, because our constitutional forefathers said that many rights were entrenching precisely because they have to be a counter-majoritarian against the elected legislature. What is so great about a legislature, Malis? Now, Malis, kindly go one by one, Malis. Therefore, Malis, consequently,
Except very small, very, very small detail,
yes,
that the legislature is the one which has created this SMA.
yes,
If you rewind and there were no SMA,
yes.
where would that right flow?
Well, it's very simple. Let us be very candid, Malis. We cannot keep fictions anymore. The legislature made the Constitution, but it made the Constitution supreme and a special majority to amend it. In other countries, that is enough to say the Constitution is supreme, not the legislature, not the judiciary, not the executive. Here, your Lordship put a supra-added basic structure on it. And who says what is basic structure? Your Lordship say that.
All that is fine. We rewind to the position that existed before 1954.
Yes.
Where could an interfaith couple come and assert that right? That is where exactly you stand today.
Now, Malis, it's a very good, interesting year your Lordship is giving. I have in my written submission even put a photograph. That's a very interesting year my Lord Justice Bhatt is giving. Malis, Brown versus Board happened around that time. There were people who wrote that these are the documents of the framers of the 14th Amendment who said you can never have equal but segregated. The original intent was against. They said we will now interpret it in accordance with evolving times. And the photo I put in my submission, Bills, is an iconic photograph of 1960 with 4 white marshals escorting a black girl. Purely counter-majoritarian. The 14th Amendment, Travaux Preparatoires, suggested that the original intent was not to allow this desegregation. and the judgment records it. It's a judgment not in the compilations. And a 9-0 judgment in 54, Justice Justice Bhatt says, at that time, we are now, what, 75 years down the line. Because it is evolving. I have got two other interesting examples when I do some research for this case. I'm digressing, but a very interesting example. You should be shocked to know. There were laws passed by legislatures of USA, the country which is the most advanced country in the world. One law said that male people below an IQ of X must be sterilized.
Eugenics.
Because you should not have a society of idiots. I'm being blunt, brother. That's virtually what judgment says. That judgment was upheld. I'm sorry, no, the law was upheld. Holmes. Second example. Second example is very, very interesting and very relevant for today. The biggest change from my time when I joined the profession is, among other things, that from being a refuge of last resort, law is an option of first choice. You would do, you'd fail 5 exams and then come to law. Now, it's an option of first choice. Secondly, people with no background in law are coming to law. With no correction, fathers, grandfathers are coming to law. Third greatest advance is women. The number of women, when some of us started our profession and now, is radically different. Whereas the second law passed in USA was, the women should be barred from joining the legal profession because of the roughness of the profession. Women are not suited. Also upheld.
We were the first to do away with that.
I beg what?
We were the first to do away with it.
That is much more advanced. Now, these are, therefore, this whole concept, original intent, legislature, it is unelected judges who are the masters of interpretation of the Supreme Court, of the Constitution. The whole idea is to entrust that power to a class of people who are not buffeted by the majoritarian trends or the majoritarian ethos of a time, which can at times be tyrannical and dictatorial. Well, part 3 is nothing but a counter-majoritarian part 3. What is part 3? It's an entrenchment against the majority. Articles 25, 26, 27, 29, 30, nothing but counter-majoritarian. So it's no point repeating. Yes, if your lordship finds that the Ghedan, which is completely test, I'm asking 10 units ahead of Ghedan, then it might be judicial legislature or should not do it. But don't not do it because the legislature may do it. That's not a valid reason. If your lordships find that your lordship has to do much more than even Ghedan allows, then your lordships may not do it. If your lordship finds that this is not a correct thing to do, your lordship may not do it. But please don't be swayed by this constant majoritarian argument. Elected legislature, unelected judges, majorities. But the whole advance of law is replete with examples to the contrary. There will be no advance in the law. And we are now talking of Brown versus Board of 1954-55.
Now, you just said that if you feel that it's not a correct thing to do, then don't do it. Or in other words, if you feel that it is a correct thing to do it, then by all means do it.
No,
the problem is that
even there within limits.
The problem is that the court decide these issues of correctness or otherwise when they are essentially issues of legislative policy and in the legislative.
Your lordship knows it better than us. Your lordship has done much more.
That's
in the course of interpretation.
Does the judge decide that this is correct and therefore we will do it? Yeah. Or is this something which properly called is for the legislature to decide as to whether it is correct?
I would even go so far as to say that there is a value judgment involved in all these cases. Was Navtej not a value judgment, Malas? Why is Navtej not a value judgment, Malas?
No,
Dr. Singhvi, Navtej was, the court was within its constitutional bounds.
Because there was a challenge to validity of
challenge.
370.
It's a challenge, Malas, by reading down that Article 14 and 15 excludes me on ascriptive characteristics. That's the one sentence summary of this case. Your lordship is preventing discrimination which is practiced by the application of discrimination against me on ascriptive characteristics. Directly 14,
therefore, let's understand your submission.
Yes.
Your argument is that any notion of marriage as a social institution which excludes same-sex couples would be violative of constitutional precept. All right?
In particular, 14, 15, etc.
That's right.
In particular.
Their argument is that marriage is conventionally understood.
Correct.
Is a heterosexual union between man and woman.
Correct.
You are saying now in order to make it constitutionally compliant, read that social institution as also comprehending within its fold
Lordship, please.
the union between a same-sex couple.
Because, no, not only that, one sentence more.
That's very different from what we did in Navtej.
No, no, well, I'm saying, no, with on one ground. One of the grounds of an ascriptive characteristic, one of the grounds of,
started the debate by saying that this Special Marriage Act provisions are void. You have not. You have said that it is raised in
if
this
I can
manner.
kindly,
If you read it literally, it
I-
leads to this.
Well, kindly see what my Lord Justice
Then
Bhatt has
thereafter
formulated.
you brought in all
No,
these.
Maharaj, kindly just see what
updating,
my,
etc.
let me answer, give me a minute, it's very important. Kindly see what my Lord Justice Bhatt has just formulated. Therefore, I could enter the gate with a voidness challenge on SMA.
Yes, you could.
Yes, Maharaj. Can I not ask for lesser? Your Lordship,
That is
read
not the
down,
point.
your
It's not a
Lordship.
question of lesser.
Maharaj, kindly.
Question is, you should be able to say, this is a wrong classification. I'm taking it head on, strike it down.
No, Maharaj, with
And
respect,
then we
with
say
respect,
we read
with
it
respect.
down.
The striking down would be on the same articles.
See, this is a very artful way of putting it, if I may say so.
Maharaj,
This is very artful.
Maharaj,
You
your
are
Lordship
not
have been on
taking
this
it
side
head
and
on.
one side, so
You are saying that there is a classification which is illegitimate.
Yes.
But you are not willing to take it that far because you have no locus.
Can I just,
You have no
I
locus.
don't, with great respect, no locus may not be right. Give me.
You are establishing, you wanting
Let
to
me-
establish a right by opposing a negative, that this is void.
So let me meet both those points. It's a very important part of the debate. Number one, I am entitled to challenge it on the ground of discrimination and an arbitrary exclusion, but the consequence, my lord is saying, must be strike down. Malice, if your lordship, within the bounds of judicial review, if, forget this case, are able to read down something, does your lordship not 100 times uphold the act by reading down? Forget this case, Malice, what your lordship do? Is the technique wrong?
Essentially,
technique is not-
proposition one, if I may say
Yeah.
so, is the classification there is valid. Now, you want to push it forward and say it is a valid classification, but
No, I'm not saying it's valid classification. I'm not saying it's valid classification. I'm
then
sorry.
in that case,
I am
heterosexual
saying by-
classification is not valid according to
Respect,
you.
brothers, no. Your classification which is invalid becomes valid by your lordship's reading spouse, person, everywhere. It can become valid, but the lordship does it in every law.
But Dr. Singhvi, there was no argument of it being ever invalid. The argument was we need the same benefits as are flowing to those who are in a
Otherwise,
marriage
otherwise it will be bad.
statute.
Otherwise, the law would be bad.
But you never laid a challenge to the very statute.
No, Malas, I'm
You said
saying
bring
I am
it up
entitled not to
now,
raise.
as we understand.
No, Malas, let me. But I'm asking, forget this case for a minute. As a proposition of law, my lords should not think that there is any sleight of hand. Just for a minute, forget this case. As a proposition of law, am I entitled to come to your lordship's court and say, A, I have direct locus. I'm directly agreed because I'm that class which is excluded. So there's no question of lack of locus. I am that class excluded. Second question, I am the class excluded because the exclusion occurs on ascriptive characteristic of gender or sex or identity. Third, if your lordships finds that there is an exclusion, then while normally the law would be struck down, I am giving you clear, simplest, minimalist answers as to why a reading of person and same sex or spouse will validate the law. I don't want to change any other part of the law.
Dr. Singhvi,
Why am I compelled, Malaj,
Dr.
to
Singhvi,
challenge its validity?
even if you were to challenge the constitutional validity of the
Yes.
Special Marriage Act,
Yeah.
even if you were to challenge
Yes,
the constitutional validity of the Special Marriage Act, that would be postulated on the hypothesis that any statutory recognition of marriage
Yes.
as being confined to a heterosexual man and woman is unconstitutional. In other words, what you would then seek is an expansion by the court of the very notion of marriage so as to include a class of relationships other than a heterosexual relationship.
Absolutely.
Right?
Absolutely.
That exactly is the problem, because then what happens is that the court, in the course of reading down,
Yes.
which you are then suggesting that it should be done, would be reading down the statute in a manner which would expand the dimensions
No,
of
reading
the
up.
social
Call it reading up.
institution, which is what you seek.
No, call it reading up. I have no problem with that semantics. Call it reading up.
Reading up or
Reading up
down.
is person.
What you are then going to
spouse.
say is that, look, the Special Marriage Act
Yes.
has taken account of marriage being a notion involving a man and a woman.
Yes.
This is unconstitutional.
Yes.
In other words, actually, if you stretch it further, that any notion of any notion of marriage itself being a union between a heterosexual man and a woman is itself unconstitutional.
Now, can I just answer that?
Now, can we, I mean,
So
can we
first part-
strike, can we go down that far and say that, look, the very social institution of marriage,
Yes.
as including a relationship only between a man and woman, is unconstitutional? Even you won't take it that far.
No, Malas, we are saying in the event that your
That's a social custom.
no, Malas, we are saying that
It's amenable to Article 13.
Malas, I'm sorry. We are
You haven't also taken it that far, and you won't take it that far.
We are saying
So, what is your next line of argument that by
tell-
recognizing marriage only in terms of a relationship between a man and woman, the legislature has infringed
I'll tell
15,
your worships.
14 or 20?
All that we are saying is that if you continue to read SMA to exclude same-sex couples, then the SMA as a legal proposition is unconstitutional under 14, 19, 15, and 21. Just allow me, Malas. I've heard it also loud and clear. First point, marriage as a legal institution needs my access on equal terms as heterosexual couples. My stoppage of access and also not on equal terms is my violation of 14 and 15. It doesn't stop here. Your Lordship, next question is, everything different is not unconstitutional. Let us see what is the difference based on. That's question number 2 in an Article 14 analysis. My answer to question number 2 would be that this differentiation, which leads to the exclusion of same-sex couples, is based solely on ascriptive characteristics. Solely. Question number 3. If it is so, then normally its exclusion must be struck down. Kindly bear with me, I'm answering your question. The exclusion must be struck down. Now that may lead to situations of inclusion.
So, this part we've understood your submission. What's the
No,
next?
but that analysis doesn't stop at 3. So first is there a differentiation, exclusion? If there is there a valid basis for it? These 2 I've made. Third still remains. Overall, is it something which your Lordship should not do after the first 2? Reading up or reading down? Because of a original intent prohibition. Answer clearly has to be no. Your Lordship will never follow the original intent in that sense in this country. Fourth,
Dr. Singhvi, during the hearing on behalf of the petitioners, I think we had trodden all this ground and even moved on. And if I recollect rightly, you said that you would not urge any interpretation which does violence to the other provisions of the statute.
that's the workability.
That's where you ended it, and the others took over. So now, please focus on what is your
That's
core
the
argument.
workability part. I'm just coming, Malas. That's the workability part. I will be showing your Lordships chapter and verse, the workability, because that is told to your Lordships. Today, Malas, I'm only on this, on the first part, a mere declaration of marriage or a declaration of a valid recognized marriage under SMA. That's the debate in the first head. I've not come to the second head yet, Malas. In the first head, it is our case that your Lordships must recognize same-sex marriage on these legal basis under the SMA. And for that, your Lordship has ultimately in the 4th test or the 3rd test only to see that does an original intent bind you? There is no such doctrine in India. Is there overall a policy of the law? The language is, it is permissible for a court to depart from the specific intent of the legislators as long as the proposed interpretation is consistent with the underlying thrust of the statute and within the institutional competence of the judiciary. If your lordship is violating this test, by all means, I'm out of the first test. Well, this is a quote from Gedan I've just read, just part. Well, Gedan was much misrepresented, factually different, contextually different. I started when philosophy recovers my arguments, of course it is. I cited it for the interpretive doctrine of judges not being bound by sterile doctrines of the original intent or the specific intention of the legislators. That is the only reason I've cited.
We don't need to go to Gaidan. We have our own homegrown
Exactly.
Ratanaria
and your lordships have in fact travelled much more. That was an English case without the constitutional dynamics of this country. So, Manus, your lordships reading up and reading down in a much bigger way is commonplace. Your lordships, Manus, in particular, apropos what my lord just has said in S.G. Chaudhary, which is, Manus, in footnote 1 and one more judgment Lakshmi video. They're all in my original compilation. Your lordship knows S.J. Chaudhary is, Manus, in my compilation, volume 2 at page 7094, and Lakshmi video is in my compilation 4, volume 2 at page 4510, held this simple proposition, Manus, which is sufficient. Application of a statute ought not to be forever circumscribed by the range of concrete circumstances that its framers intended it to apply to. This is your lordship, 60s doctrine. Gedan was one, I've given your lordship enough Indian law before that. Therefore, I submit.
There's an old one on 14. I think it's Jialal. Jialal is, I think, the one where those living on the other side of the Yamuna were not allowed to hold an arms license. And that rule was, created during the aftermath of the mutiny. I think it's 61 or 62.
Oh, yes.
So the court said that, what is this classification? See, that which was valid, because the insurgents were holding arms, they were concentrating in Meerut and that side. Correct. So they wanted to stop that.
So that was a contextual thing of that time.
Correct. So then,
that's right. Then, I go on this to say that your lordship will then juxtapose it with the agnostic thrust of the SMA. Why was the SMA created? Well, today, after 70 years of the Republic, 75 years, we have a recognition that the numbers of same-sex or queer people is very large. They were always there, but they were not understood and recognized as a community, that they existed. There was fear on both sides, both on the heterosexual side and on the homosexual side. There was inhibition. Today, what is this case about, Paulus? That your lordship provided a secular agnostic platform for heterosexuals. Forget, Paulus, this category. SMA's entire birth from two things, Paulus, the long title and the SOR. I'm not showing it again, lordship. And, Paulus, the text, especially 4, section 4. The whole purpose therefore, if the SMA was designed to facilitate marriages, actually, SMA was in that sense not as much, I would say, but a very significant advance. Not so much as recognizing same-sex today, but a very significant advance because it was also dealing with marriages outside the pale of social acceptability. Well, social acceptability is the heart of SMA. Your lordships wanted to create a platform for social acceptability which is not there for heterosexual couples.
Now, just a little look at the clock, Dr. Singhvi. We don't want to keep it part-head beyond the vacation.
No, tomorrow a little bit. I will not.
We have about 50 minutes. We'll rise at about 4:15. So between all of you, please ration the time now.
No, tomorrow, give me some time. You also will do one thing. Rise at 4 o'clock. Give me about half an hour, 45 minutes tomorrow. We'll finish this side. Then I won't. workability and all, but this is a matter of last, rejoinder is the last stage, well, we want that time.
Singhvi, tomorrow is a crowded morning. We have a
There is a reference.
Then we have two constitution bench judgments which we are pronouncing tomorrow. Plus, today we had only 240 mentionings in the morning.
Well, your lordships may slash
276, sorry, 276.
Your lordship may shift the mentionings to next week, well, in a lighter vein, because well, this can finish too.
And then we have all India.
This is our last slot, well, and a rejoinder.
Singhvi, you can just
It's the last
do
slot.
one after another. Tell us because we have heard it for such a long time.
No, well,
This will be faster to grasp it. You just formulate it and then tell
no,
us.
well, I'm formulating as I go along, well, I mean, I'm giving your lordship every discrete point. I'm not repeating a point, because this is a matter of some moment. Your lordship will give me some time tomorrow. I'll be very pointed. And well, your lordship has time from 12 o'clock for this matter, or from whenever your lordship finishes the other thing.
Only 10 minutes to give a suggestion.
I'll tell you what the practicality is.
Yes.
The reference will go on for about
This is
what we could do is this, because tomorrow's schedule really, I mean, I must share it with you. We have the reference which we anticipate would be 10:30 to 11. Maybe perhaps a little longer.
mentioning half an hour.
Then we have two constitution benches, give 20 minutes for that. Mentioning half an hour. So we would be able to assemble at about 12 o'clock.
12.
12 o'clock. So 12 to 1, then everybody will have to wrap up between 12 and 1.
We'll finish it by 1 hour.
But no, I just want 5 minutes now. I have difficulty to.
Another 5 minutes after Mr. Rodgi.
Only
two of us will finish.
I want to give a suggestion.
We'll finish.
I want to give a suggestion. If you not-
Singhvi, if you could please do this, if you could wrap up by say about 3:50, then we can give 5 minutes each to Mr. Rodgi and Mr. Ramchandran, and then see who else remains there.
Let me
1 hour.
In 1 hour.
it's 3:30. Well, let me proceed as fast as I can. If I need 5-10 minutes.
Give me 20 minutes because. Please keep going.
Please.
You are my friend.
My-
Take time tomorrow. Give me and Ramchandran 5, 10 minutes now, and he can continue tomorrow.
Anyway,
He will not just give.
Now we're in the thick and the flow of Mr. Dr.
Now, well, so let me
Let
utilize this time at least. Well, I mean, let me just go.
All right, Dr.
Now,
Singhvi.
now
yes.
I'll go back. So, now, therefore, your lordships provided a platform of beyond social acceptability for heterosexual couples. All that your lordship has to see whether reading in or reading up within that social acceptability platform is beyond the pale of judicial review. That's the only test.
That's the point.
I'm not asking your lordships. I heavily disagree about judicial
What you're
surgery.
saying is Gaidan
Yes.
methodology and
Not Gaidar, but
is-
principle.
okay, whatever it
Principle.
may be,
Yes.
is equally permissible under the constitution.
Now, Wallace, kindly turn to para 9 of my note, my written submission. I made a self-contained, Wallace,
In-
the rejoinder
rejoinder,
submission.
right?
Justice,
In rejoinder.
yes, what is
Right.
it called?
है ना?
It's got my name on the top, Wallace, rejoinder submission by so-and-so.
अभी आया है दोपहर को.
It's from right now.
Where is that?
Yeah.
The mail is it?
सुनो,
from
आप
the
तो
mail.
इसमें आपने
Well, we have got hard copy.
किया है. Rejoinder. There is a mail, is it? Mail में भेजा है?
Volume up to volume 18, huh?
चेतन पेन ड्राइव में कहाँ पर है? They
Up
told
to
me that
volume
they added
18.
it.
Now, Wallace, have you got page 9 at page,
Give us a moment, Dr. Singh, we're still looking.
para 9 at page 5.
Joinder is a whole new world now.
Karunanand, he has given two.
Is it by way of the conclusion on this point, Dr. Singhvi? Does it begin like that?
I will. Yes,
It's done.
एक
Yes,
page
we
है.
got it.
yes, correct.
we have to
Justice
turn.
Call has got
Cyril,
it. Para 9. That's
mail में है
correct.
क्या?
Justice Call has got it.
हाँ, किसमें डाला है?
Para 9 is well as at page 5.
Rejoinder folder
Yeah.
अलग नहीं है मेरे पास.
It's a 37-page document.
There's an extra. There's actually 15 pages. It's only 15 pages. Or
Yes,
maybe
you're
more
right.
than 15. How many pages? 19 pages, I'm sorry. 19. Rest is well as appendix.
Yes, you're right.
Now let us just come to 9.
Is the rejoinder folder in as part of written submissions?
Still looking,
Chetan?
looking.
Oh,
Because
I'm
came at lunch, therefore there was a problem.
Let it be located first.
It's sending it to you.
Justice Kaur and Justice Bhatt have got it.
No, we have it.
Justice Narasimha also has it.
No, he's getting airdrops.
Hello?
You also. Will you airdrop it to me?
Airdropping is, your thing is not on.
Fine.
No, this CJS.
So, no, yes.
Got it? Somebody can just go that side and find it.
Because they took my pen drive to load it in the afternoon.
Which one?
Okay.
These written submissions in rejoinder.
Yes, just
20
police
pages.
computer.
Yes.
Just to
Yeah, sure. Just one second.
give us a moment.
It's a 20-page
Download.
document. Yeah. It's 37 pages, by the way.
37.
Actually, 20 pages is
20
the
is submission.
He has to argue in rejoinder. That's
Correct,
his
that's
base.
right.
Para 9 at page 5, internal page 5. In the middle. Sorry. It was never in dispute that when the 14th Amendment was enacted in 1868, its framers did not intend it to apply to desegregation. Indeed, it is popularly recounted that many legislators who supported the amendment supported segregation and the separate but equal doctrine. In Brown, however, the US Supreme Court discounted the specific application intent of the framers and asked itself instead what the principle of equality required of it by way of constitutional interpretation. Similarly, petitioners' interpretation of the SMA focuses upon the underlying thrust and the principle of recognizing and legitimizing marriages unsupported in social conventions, upon which the SMA is founded, rather than asking how the framers intended to decide. That question is wrong, I say with respect. Now, I'm putting that photograph, I've said anti-majoritarian impulses. Unpopular, I'll skip para 9a, but that's an iconic photograph of the 1960s. Come to para 10. Petitioners respectfully submit that the remedy does not involve any judicial surgery, nor the creation of a social new institution, nor a claim for legislation. These are words used by the respondents. Now, kindly see what it involves. Rather, the issue before this court is one of discrimination of non heterosexual persons from an already legally defined institution on the basis of the prohibited markers under Article 15. Malas, one thing more, Malas. Your Lordship is told social institution. Today it's more a legal institution because your Lordship under the SMA is excluding personal laws. It's a misnomer to again and again bring this scarecrow argument of personal laws. It's a legal institution under SMA, not a social institution. I'm not saying marriage is not a social institution.
It's not as it is
Not,
it is
I mean, I can
creating,
say it,
it
not
is
absolute.
it is enabling the marriage, but it is also assimilating
I
person.
bow down. I don't want to say, use the word absolute. My Lord is absolutely right. That matters, I'm not going that far. I'm just saying, Malas, a large amount of that social institution part has been, Malas, circumscribed by a legal construct, which is what SMA is. Prior to that, your lordships could not venture there without personal laws. That's the point I'm making. Now, just see the middle of para 10 is very important. I've taken the liberty of highlighting it. A right to marry, along with a scheme for its implementation, already exists. Petitioners are only asking for a non-discriminatory access to their existing right and institution. Indeed, petitioner's request is modest. It is to interpret certain provision of SMA in a manner that is both constitution compliant and consistent with the SMA's own underlying thrust. Contrary to the respondent's submission, this does not involve the court in altering the meaning of words or the meaning of marriage. It only brings into the ambit of the SMA a class that was unconstitutionally hitherto excluded. Well, your lordship is just pause here. I'm not on the notice and objection. Your lordship is now being told an equation between right to marry, a declaration to marry, versus a declaration to marry under SMA. Malas, Cicero's words are important, Malas. Cicero said, Malas, that a room without books is like a body without a soul. Malas, your lordship is being asked by the other side that you recognize an abstract right to marriage without anything under the SMA is really being asking for a body without a soul. That's my submission, Malas. That I've said in para 10 capital A. And Malas, we have a quote, Malas, in the top of my submissions, which I need not, Malas, Mary Robinson, President, Ireland, and also, Malas, the promises of human rights are like empty shells if they are not backed by concrete actions and meaningful change. Malas, may I say, your lordships is, what is your lordship being asked? Give a declaration of marriage, but nothing to do with the SMA. These two words, empty shells, Malas, apply, body without a soul apply clearly. Now, Malas, 10B, I've said legislative majorities did not decriminalize. Forget 10C, Malas. Come to 10D. 10D for a minute, Malas. It is respectfully submitted that legislative will is not necessarily a neutral, objective, or meritorious manifestation of desired constitutional objectives and constitutional morality. The Constitution is supreme precisely because in many areas it digresses from the wishes of mere electoral majorities. The zealous guarding and upholding of several minority rights, including its many nuances, is crucial precisely because electoral majorities are presumed to be wrong, tyrannical, or oppressive at certain times. So, Malas, this is an excessive misplaced reliance on elected majorities and unelected judges on the other side of the equation. Now, Manas, let's go to workability, which is the heart of the matter, because I must assuage all these huge apprehensions, which I'm going to show are largely red herrings, created, Manas, to create some kind of a Manas, fear issue that, oh, what is the lordship being asked to do? How far a lordship will go? Now, Manas, please see, the main part of this workability or lack of workability is personal laws. That your lordship is being dragged into personal laws. Just bear with me, this is a little important, and I'll go a little slow. Just come to the third line of 11. In particular, section 19 of the SMA severs ties of persons of Hindu, Buddhist, Sikh, or Jain religions married under SMA from their undivided family. At the same time, 21 provides that succession to the property of any person married under SMA is under ISA. Now, the main argument on which, well, on the very tenuous, thin argument it is argued by respondents is the last 5 lines. Respondents argue that 21A of the SMA carves out an exception for marriages among persons of these 4 faiths, stating that they remain members of their undivided families, last 4 words, thus linking them back to religious and personal laws. Now, I'm trying to answer this first point. Well, I've given 2 important tables in para 12. Just see the first table. Prior to 20, because the entire argument is 21A brings back a very minimalist, but a small amount of personal law. Now, prior to 21A is my first table. Everything is ISA. Let's kindly go a little slower. It's very important to remove these apprehensions. Everything in my first part of the table is ISA. ISA is supposed to be an agnostic, civic, secular law, which goes in tandem with this equally agnostic, civic, secular law like SMA. There is no Hindu-Muslim personal law involved. And the first part, even for Hindus, is a severance from the HUF. All the columns are ISA, 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 Muslim, Christian, everything. Now, after 21A mullahs, it remains the same, except for a Hindu couple. Well, I hope I'm clear with this. Except for a Hindu couple, the second part of my table is identical to the first part.
What you're saying.
Now, let's kindly go. Yes, therefore take it slowly. I'm dealing with that. Petitioners submit that 21A does not create a barrier to a constitution-compliant reading. 21A only applies for marriages of 2 Hindus. Further, even when 2 Hindus marry under SMA, 21A links the SMA regime to personal law for only 2 narrow aspects. The whole case should go out of SMA because of this argument was according to respondents. Succession and membership of HUF. Succession and HUF, that's all. So 21A is A, limited to succession and HUF, second limited to 2 Hindus. Now, let's kindly come to my answers. I am respectfully submitting 3 possible interpretive answers. And your lordship, I am neutral to all. I have a personal choice. It doesn't matter. There are people here, other people. All 3, according to me, it's a scare argument to say that so much big is happening, whereas these 3, any one of them, your lordship's choice answers it. Firstly, theoretically, this honorable court may elect not to pronounce on the applicability of 21A to non-heterosexual Hindu couples in the present litigation and leave questions of succession open for future litigation expressly. That's only option 1. See option 2. Secondly, in the alternative, the honorable court may hold that the SMA will apply to non-heterosexual couples exactly as it applies to heterosexual couples. Today, your lordship has it applying to heterosexual couples. By virtue of the introduction of 21A, specifically, Hindu non-heterosexual couples will be governed by the HSA, just like Hindu heterosexual couples. But all non-Hindu, Christian, Muslim, will be governed by ISA. This is number 2.
But to achieve this reading, now read what follows.
Yes.
What do we have?
I have to. Is your lordship's shy of doing this minimalist interpretation? Will be the question. That's the value judgment of your lordships. If I am asking for something which your lordship has never done before or is unknown to your lordship, is right. I submit this is a minimalist. See the next. Yes, next para. This is minimalist, is my submission. To achieve this reading, the honorable court may extend its gender-neutral reading of the SMA to the HSA and the ISA. That's all the lordships do. Whatever it has to hold: 1, widow and widower in the ISA, and male Hindu and female Hindu and widow and widower in the HSA shall be interpreted in a manner that is agnostic of gender and sexual orientation. That too, Malas, there are 2 options. By specifically saying personal law is out.
Really have to then recast or redraft the provisions of the Hindu Succession Act also.
No, your lordship, it doesn't have to recast it. Your lordship has to say, no, my lord is only in SMA. My lord is not going to HSA. My lord is saying either of 2 things.
You're saying that to achieve this reading,
yes,
this honorable court may extend its gender-neutral reading of the SMA to the HSA and ISA. It may hold that the words widow, widower in the Indian Succession Act, limited to issues of marriage, and male Hindu, female Hindu, widow and widower in the Hindu Succession Act, again limited to issues of marriage, shall be interpreted in a manner that is agnostic of gender and
Correct,
sexual
correct, brother,
orientation.
correct, correct. Now, what does it mean? Give me a minute. It's very important. Give me a minute. It means that your lordships will first put a caveat in the beginning. We are not getting into personal laws. Second, cumulatively, your lordship would say that today all heterosexual couples are governed with 21A in only ISA, except for Hindu couples. So the large majority of non-Hindu couples are covered by ISA. Third, third.
The largest number of people.
No, that's the third. So I'm not avoiding it. I'm not avoiding it. I understand. My lord is right. Third, for the Hindu couples, the agnostic reading will be to words like male, female, widow, widower.
In other words, we are creating a new regime, essentially. There.
Because that may not be a new regime. Because that is because even in,
No, it's not. If you go down, drill down a little bit, the complication.
Yes.
Now, two spouses of the same sex, one dies. Now, who will that be? What is the kind of estate that she?
if your lordship
entitled to?
adopts, Malas, if your that's the may I read?
Well, then you see when it comes to a male, of course it will be a son. He will be treated as a son. When it is a female, he will be treated as a daughter. Question is, what is that spouse? Will he be treated? Will that spouse be treated as husband?
When a male Hindu dies intestate, but the first priority is to the widow. If it's a same-sex male couple and the male has died intestate, there'd be no widow.
No, Malas, there will be.
So what you are now therefore saying is that read widow.
Reading that to be a compliant. He's the widow.
Another word for the word widow.
Willy-nilly, we do enter into personal law.
Or, Malas,
See, this formulation has one.
surviving spouse.
No,
That's true.
See,
That's true.
it's a bit oversimplistic. Hindus, you say only Hindus. No problem. But at the same time, there is no problem when it comes to Indian Succession Act, where the Christians, it anyway applies to them.
No, I have no problem with ISA.
When we come to the Muslims, are the
21
one
is
who-
creating a problem.
Muslims are the one who are now bound by the ISA.
Yes. No, may I just
Others,
no, may I just say there's a third option I'm given. The problem is arising because of 21A, which takes you back. It is not arising for any other category. So Muslims and Christians who go under heterosexual couples under SMA go under ISA.
But Dr.
Now, Malas, the third one is
look at how that third, you are yourself struggling at an intellectual level. You say it is submitted that there is a third option.
Yes.
That this honorable court may hold that since religious and personal law related issues by agreement of parties are beyond the scope of
that's what I started the matter with, Malas. We are saying outside.
We can't rule
No,
on.
but we started the matter
by
by
saying
saying
that look, by agreement of parties, this
No,
has been
forget
kept away
agreement,
and create
Malas.
a minefield for a future bench.
Malas, forget the agreement. Your lordships is saying that from the inception, the petitioners, Malas, the petitioner, kindly read the whole.
You have to then decide it.
No, Malas, kindly allow me. No. Malas, kindly read the whole para. This matter started by the petitioners who invoked your lordship's court to say we don't want to get into personal laws. Your lordship can certainly rely on that petition. But now read the whole para. Just allow me. Third para. It is simply the third option. This honorable court may hold that since religious and personal law related issues, forget agreement of parties, I need to delete that word. I mean, I don't want to, not necessarily, are beyond the scope of this litigation, which your lordship declared at the beginning when the matter started. It follows that personal law statutes, as well as provisions of secular laws that relate back to personal laws, that is only 21A, are excluded from consideration. Since 21A itself was introduced as an exception to the regime under 19 to 21, non-consideration of the issue would simply mean a reversion to the default regime of ISA.
So are we reading up or are we reading down by doing that?
Well,
Which of the two would it fall under?
well, I am saying there are two options. Either it will all fall under ISA or your lordship may apply the
so then we have
spouse
to-
and person
we-
interpretation for HSA
So
Hindus.
then we come back to the old position that when it comes to same-sex couples, we will interpret it in a particular manner. When it comes to heterosexual couples, we will read all those laws in a different manner.
Well,
We will have to have those
in
two
option
different
two-
interpretive tools.
well, so can I just summarize? After a preliminary statement that when the matter started, your lordship had made it clear, and the petitioners have also said that there is no going into personal law. Your lordship may adopt either of two. Allow me to summarize. One, that everybody is under ISA and 21A will not apply to the same sex. Alternatively, that balance, everyone is under ISA because ISA is not posing a problem. But for same-sex Hindu couples, your lordship reads the word spouse or a word person. That's the summary of the whole thing. That much your lordship will have to do. If it is beyond the bounds of judicial balance writing, it is beyond the bounds.
Should we preclude Hindu?
Please see the logic in my para 15. But I am saying this cannot be the complete exclusion which the
Then
respondents would want.
then there is a classification amongst the same-sex couples. You are saying that those who fall in 21A, you treat them differently, leave it at that. For the others, you have ISA.
No,
You are actually subclassifying now.
No, not in the second option, in the third option, yes. In the second option, the better option is whether your lordship interprets it to mean spouse or person. Then there is no
So
such
Hindu
problem.
non-heterosexual couples would be governed exclusively by the ISA, according to you.
How is that possible?
On option 3, not on option 2. This is important. Let us forget option 3.
Then neither are we reading down, nor are we reading up, nor are we striking down 21A.
No, so let me leave aside option 3. Let us say that your lordship keeps 21A.
Dr. Singhvi, we are not writing a blog, we are writing a judgment for society.
Your lordship is keeping 21A. Let me tell your lordship how I would respectfully submit a judgment can be written with 21A existing. It will certainly not be a blog, Balas.
You may have that legislator's pen elsewhere. But you can't persuade us to use this here.
I can only make a submission. Balas, let us just for a minute focus on 21A.
Yes.
Your lordships may adopt the second option. 21A is given full force if your lordship reads the word spouse and person. That's one sentence answer. Forget the third option. 21A is excluded, as my Lord Justice Bhatt said, only in the third option. In second option, since 21A is there, your lordship applies it, but your lordship would have to do person or spouse that much of reading. That's the long and short of it. Now, is it such an insuperable thing that the whole case should be a mere declaration of marriage? Then there is virtually an empty shell. I would say it is only a cardiac checkup.
Or is it a transplant?
That too, cardiac checkup, that too by a physician, not a surgeon.
Ultimately,
Physician.
Court, please have heart. That's what it is saying.
That's neatly put.
Let's just see the conclusion at para 15.
Yes.
Just see the conclusion at para 15. Because then I have these special categories coming after that. It would not follow from this approach. Now I am giving the answer to a possible objection to my approach. It would not follow from this approach that non-heterosexual Hindu couples who marry under SMA would be excluded from legal succession regimes altogether. Today,